Now, Mr. Hyden, Mr. Tilliard, I understand your client's not here at the moment. What's the position?
My lord, the position is that they arrived in Paddington having had a train that was cancelled at about 10 past 10. But they were only successful in getting a tube at about 10:30. So our estimate that we'd be ready to start between 11:15 and 11 o'clock was ambitious, we thought, and in those circumstances, we thought you may wish to proceed. They're aware of that possibility, and we've invited them to join us at the back of the court when they arrive. My lord,
How long are your submissions going to take, do you think? 'Cause
I would have thought, depending on how much I'm asked, about an hour on my part.
Mr. Tilliard.
I'm probably the same. I wouldn't have thought I'm longer than an hour, certainly. But, my lord, we've informed our client that to come in as and when they arrive, and I suspect that they'll be here relatively quickly, and they will be able to follow most of what's being discussed.
Well, let's proceed then. Yes. Well, now, just to let you know, we've read much of the documents. We read the key part documents, obviously the judgment, grounds of appeal, some of the medical evidence. We don't have the advantage of transcripts. There's a lot of toing and froing about transcripts. Are you all content to proceed without transcripts?
We are. You'll see there's agreement between us in relation to the law, so you have no bundle of authorities.
Yeah.
And there's agreement between us that what each of us have said in our respective skeletons reflects accurately the evidence that was given by the respective experts and by the parents. Yeah. And in those circumstances, we can do without them.
Well, that's very good. We're grateful to you for doing that. Could you just help us with what the current position is with the family? And do we have any clear idea of what the future holds?
So the position is that the child and the parents, I'm conscious that we're being live streamed.
We are being live streamed, so we must all be careful not to mention.
I was simply, subject to your lordship's better view, going to refer to the child as the child and the parents as mother and father.
That's right.
The child and the parents remain living together with the maternal grandparents, as they have been doing since the discharge from hospital back in March of
2 years ago.
2022.
Yeah.
It is the local authorities' position, and always has been, as I understand it, that they don't consider that they will remove the child from the parents' care. When your lordship gave us permission to appeal and the proceedings were stayed, I suspect, unintended consequence of that was that the local authority did not proceed with the assessments that they were going to undertake, which, as I understand it, are geared towards assessing to what extent the parents accept that there is a risk moving forward. We have always, put it bluntly, made it pretty clear that, as you will have seen, neither parents accept responsibility for what has occurred, and that is a position that is likely to be maintained.
Is the proposal to carry out a sort of resolutions type assessment?
That sort of thing.
That being, for the benefit of those who don't know, an assessment carried out on the basis of findings which are not wholly accepted by the alleged perpetrators.
My lord, yes, and as I understand it, there was some significant difficulty in identifying somebody to undertake that role within reasonable timescales. So
there used to be somebody down in the West Country who did it a lot, Mr. Nicholson.
I think I think in the end it was somebody from the West Country. Yeah, and the short answer to your lordship's point is we have some few months, I think, to go before this case will be resolved. But unless I misunderstand the position, come what may, there is no suggestion that the parents and child will be separated.
Can I just turn to you, Ms. Harris? Is that correct? Can you say that as firmly?
It is correct. There, of course, would have been an assessment as a consequence of the findings that were made, and whilst we can't prejudge that assessment, everything that the local authority have seen the parenting of this child has been very positive, and we acknowledge that but for this event we would not be here. There is also a positively assessed set of grandparents, which are the maternal grandparents that the child currently resides with, and they have been positively assessed as potential SGO carers. So there is no question, even if things change drastically during the assessment process, that this child will be removed from the family. And my learned friend Mr. Hyde is correct that there had been an issue with a resolutions type assessment because of the duration. It would have been a 3 months risk assessment followed by a 6-month resolution work process. Her Honour Judge Cronin took the view that that was too long. We identified another assessor who would do the first 3 months, not strictly resolution, but resolution type work. And then there was a problem with that assessor doing the work totally unrelated to anything to do with this case. So we didn't have an assessor identified, at which point the proceedings were stayed. So that's the history.
Thank you. Yes, Mr. Hyde.
My Lord, if I may, before I turn to the particular grounds of the appeal, I'd just like to make 1 or 2 general points by way of background.
Yes.
And from this conversation that we've just had, my Lord, you know that the child was admitted to hospital in February 2022, just then a few weeks old. And the background to that admission is uncontentious. There was a sudden collapse in the early hours of the morning. The medical evidence was that the causative event would have occurred close to or immediately that the child's behaviour was seen to change from normal. In other words, we have again undisputed evidence that the child was seen to scream and arch her back and rapidly deteriorate. At that time, she was in the sole care of her father. Her mother was downstairs. She'd been downstairs for about 5 minutes when she heard a scream, having left the child stirring 5 minutes earlier with next to the father. And the issue, therefore, for the learned judge was to determine whether the local authority had established its case that this collapse was caused by some traumatic event that was inflicted by one or other or both of the parents. And in the event that she was unable to, in the event that she was satisfied that it was as a result of traumatic force, and she was unable to determine which of the parents had caused it, to consider whether they should each remain in the pool of perpetrators. That was the broad canvas against which the judge was working. In relation to the cause of the collapse itself, there was undisputed medical evidence that an avulsed bridging vein had given rise to bleeding, which had collected, and that ultimately required emergency surgery. But, my Lord, there was a difference of opinion, and we say significant for reasons that I'll come on to in a moment, in relation to the number of injuries that could be identified on the child. And I say immediately, apart from a small scratch above her left ear, which no one considered to be of consequence, the only injuries were those that were identified as a result of X-ray and CT scan. And the difference of opinion related to whether there were contusion injuries and whether there was multifocal thin layer bleeding.
the contusion injuries were internal, were they?
Yes. So
Or said to be internal?
said to be internal, identified on the brain, and for reasons I'll come on to in a moment, used as evidence by some of the experts to support a theory or a hypothesis that the child was shaken. The theory being that as the child was shaken, the brain moved around in the skull and caused bruising to the brain. There was, and it's possibly a good time to identify that now, there was therefore some issue between the experts as to the mechanism that would have caused the injuries that were identified. If the injuries were caused by shaking, one would have expected to see, in particular, the multifocal bleeding that one of the experts identified as being present. However, as we set out in our grounds of appeal, the judge found, or was unable to find, that either there was contusion injury or that there was multifocal bleeding. And therefore we had this very curious position in the sense that if the child had been subject to shaking, none of the other injuries associated with shaking was present. And in particular, shaking had occurred with such force that caused the rupture of a bridging vein, but had not damaged any other of the more fragile blood vessels that give rise to thin film bleeds. And it's important to understand, I think, as we were told by the neurosurgeon, that the thin film bleeding is very different from what was being observed here, the avulsed bridging vein. And that circumstance of having simply an avulsed bridging vein without any other damage to the blood vessels causing thin film bleeds presented for the pediatric neuroradiologists a unique situation. And you will have seen, I think, in the bundle, it's at F130, the table that was produced at my learned friend Mr. Tilliard's request. My lord, I can take you to it. It's F130 in the paper bundle and 332, I think, in the PDF bundle.
I'm sorry, F130, did you say?
F130, yes, please.
Thank you. So this is
Sorry, which page number is it on? F1.
F130, please, my lady.
Thank you.
this is a table produced by Dr. Stivaros, is that right?
Correct. And the genesis of this table is that he was asked by Mr. Tilliard if he would be able to look back over all the cases where there had been a space-occupying subdural collection and to identify in any of those cases where there had been a shaking episode or associated impact injury, there was also multi-locational bleeding. So if one looks down the two left-hand columns, you will see that in every case where there was a space-occupying subdural collection as a result of a shake or shake with associated impact, multi-locational bleeding had been present. So this, for him at least, would have been unique. If one looks at the other possibility, in other words, that there had been an impact which caused this avulsed bridging vein, the experts again had told us, and Professor Stivaros gave examples of a child falling from a tree house or a child falling downstairs. And the neurosurgeon, Mr. Jayamon, told us about child falling off a sofa onto a floor and again falling down the stairs.
Yes.
Those were the sort of accidents that would be required to produce, as Mr. Jayamon said, the significant trauma that would be required to rupture the bridging vein if the causation was by force. But the trouble was that despite the force that would have been required, there wasn't, apart from this scratch to which I've alluded, a single mark on the child. In other words, the mechanism, if it was by force, had resulted in an isolated avulsed bridging vein with no other damage. And the reason, my lord, that I set the scene by taking you through that is our submission is that having those unusual set of features, the judicial antennae should have been twitching when listening to the medical evidence.
Well, of course, there was a conflict, wasn't there, as to whether or not there were multifocal leads present.
One, the conflict should have alerted to the judge to this not being entirely straightforward. But of course, the context in which we bring this appeal is that the judge has not found them to be present, nor has she found...
Mr. Stivaros, who I've not come across before, he thought there were, have I got that right?
Yes,
And he's the radiologist.
yes.
The other evidence, Mr. Jayamon in particular, disagreed.
Correct. I think the important thing, my lord, to take on board is that, well, two things. One is I responded quickly to your suggestion that Mr. Jayamon disagreed. In fact, by the time the experts had their professional meeting, Mr. Jayamon deferred to Professor Stivaros.
Okay, right.
And I can't pass up the opportunity to mention the experts meeting, because it was, in my submission, an unfortunate feature of the case. We have a transcript of the experts meeting. It lasted no more than 30 minutes. And the solicitor for the Guardian concludes with something like, that's a record, well done, under 30 minutes or something. And again, I'm sure it doesn't represent the care with which everyone looked at the case. But notwithstanding, it's clear from Mr. Jayamon's report that he was saying, I need to defer to Professor Stivaros, but actually when I look at the CT scan myself, I can't see these as separate focal bleeds. It looks to me like it is bleeding that's contiguous with the avulsed bridging lane, and that indeed is what the radiologist in the hospital had said.
Yes.
He deferred to Professor Stivaros. The importance of that is that Dr. Rylance, the paediatrician who brought everything together, proceeded on the basis that the contusion injury existed and the multi-locational bleed also existed. And so when the judge, and this forms part of our ground, and I'll come on to this later if I may, when the judge reached the conclusion that she couldn't find that these two other injuries existed, it had a significant impact, or we say should have had a significant impact on her assessment of the medical evidence.
She didn't find positively that they didn't take place. She simply
I'm so sorry, my lord, I'm very hard of hearing.
she didn't find positively that there was no other contusion or multilocational bleeding. She just left it open. Is that right?
She, my lord, she was unable to find that they existed. My lord, you're right that she did not find that they existed. She said in her judgment, and I can take you to it on the points of clarification, I stopped firmly at finding that there was an advanced bridging there. In fact,
Shall we look at exactly what she said?
Yes,
This
certainly.
is absolutely crucial
yeah.
to your case, it seems to me. For my part, I've never come across, you'll be aware of, this is not the first time we've had issues about clarifications in this court recently. This is the first time I've come across a judgment with track changes,
Yeah,
which
well,
is quite helpful, actually.
we were
Well,
very conscious, I'll take you to the reference in a moment, my lord. We were very conscious of the parameters in which we should put our points of clarification. And
Good.
we had received the written judgment about a fortnight after we'd made our oral submission. And we both filed written points of clarification in the hope that that would allow her to consider them before we came back for the hearing.
Yes.
In fact, we came back about a month later, and it was clear, I'm not making a criticism here, it was clear that the judge hadn't considered them. So we dealt with them orally.
Yes.
And so, my lord, we have the transcript of the proceedings
Yeah.
at E39, which
Yes.
is PDF 183.
Yeah.
And I think actually now it's a struggle to find the reference. I'll find it for my lord in a second. I deal with it in my. Second.
Is it this passage? I stopped there, Professor.
Yes, please. Where is that?
It's at E42.
Thank you. Very grateful to Mr. Suziardi. E42. And at
Letter F.
yeah. So I start by inviting her to look at the document that I have sent, which is also, my lord, in the bundle. And as you see, she works between what I've asked her and her judgment. And it's an important passage for a number of reasons. First, I'm having to ask her whether she found the presence of contusions to be established. And from the outset, I would suggest that that was something that should have been at the forefront of her mind. It didn't feature in the judgment at all. And in fact, reading that paragraph, I'm perhaps hasty to say that she did not expressly find contusions present. That could be read as she specifically did not find.
At letter F, she said, the
Contusions.
first question is whether or not I found contusions present.
Correct.
I did not find contusions present on the CT scan. And then we see what she says after that.
Yeah.
I stopped firm at the finding there was a torn bridging vein. Does she deal with the multifocal points?
She had dealt with that in the judgment itself.
Okay.
And again, we can turn to that. And I'm relatively confident. She says she's not satisfied that there were multifocal.
She does.
injuries.
Paragraph 113.
Thank you.
So she doesn't revisit that. That's not mentioned in this.
We didn't need to revisit that.
Right.
And my submission was going to be, even if she had not positively found something not to exist, forgive me, too many negatives in that sentence, but having the local authority having failed to establish that something did exist, my submission would be that the court would have to proceed on the basis that they didn't, as a matter of law. But in fact, having read that passage, it's clear the judge goes further than that in her finding that the contusions were not present.
Well, there's a difference between saying, I am not satisfied she had multi-locational bleeding, and
Yes.
saying, I am satisfied that she did not have multi-locational bleeding. Just as there's a difference between saying, I did not find contusions present, and saying, I find that there were no contusions present. And that's why I asked whether she just left it open. And I mean, I understand your point that it's for the local authority to establish their case, and if they don't establish it, then it's not been established. That's not the same as saying she makes a positive finding that things were absent, is it?
So I fully accept the point, my lord. Two points I would want to make in reply. One is, if she had been unsure about whether they existed or not, my submission, it should form part of the analysis. Given the uncertainty I have about whether these existed, I need to approach this medical evidence with care. That's one general point I would make. The second point I would repeat, and I may be on less firm territory. It seems to me, as a matter of law, in an analysis of facts, if one cannot reach a point at which you can say this fact occurred, it must follow that we proceed on the basis that the fact was not established. Therefore, it did not occur.
Lord Hoffman. Lord Hoffman.
Yeah.
Well, Lord Hoffman does say that in one of the cases. He says it's a binary, and it returns either a value of 1 or 0. So if it returns a value of 0, you treat it as not having happened. But where you are going to build on the absence of, let's take contusions.
Yes.
The way you opened this appeal to us was that the absence of contusions was a very striking phenomenon and gave rise to various consequences. I have a slight reticence about saying, because something's not been established, therefore you treat it as not established, therefore you can build consequences on the fact it wasn't there, which is because it would be unusual if it wasn't there. I'm not sure that's what Lord Hoffman meant, or whether it accords with the way in which ordinary reasoning works.
Well, I can see the distinction, I believe.
Charles, can I you have seen 130. I did not find contusions present on the CT scan.
Yes, no, I think we've dealt, my learned friend, my lord, I come back to your point, my learned friend is drawing my attention to paragraph 113, where again we have reference to, I did not find contusion. Yes. So I think the contusions, I'm on safe ground in saying there is a positive finding that they didn't exist. To return to your lordship's point, I can see the distinction in terms of a factual analysis of a case where you have to approach the evidence on the basis that you may not be satisfied that a particular component is established before reaching your ultimate conclusion. But that would lead me back to the previous point that I made. If that is the way you are going to approach it, then as a judge, there must be a high duty on you to explain exactly how you've made that analysis. Lord, I don't think I can do any better
thank you.
than that. Turning therefore, if I may, to the analysis that is undertaken by the judge. It is clear, we say, and I'm going to deal with this in some detail in a moment or two, that the learned judge considered the medical evidence, concluded that the medical evidence resulted in her being driven to the conclusion that there must have been, her words, there must have been a traumatic event. Indeed, she described it as abusive. And that was the reason that she did not accept what the parents had told her. And we say that that demonstrates that she did not analyse the parents' evidence, notwithstanding that she recognised it was a vital part of her function to do so. And I'm going to come on, if I may, and deal with the specific points about that. With great respect to the learned judge, the analysis, we say, is lacking in any event. And my lord, if I could, I would just like you, please, to look with me briefly at this stage at the judgment. And if we could pick it up, please, at paragraph 54, which is at E11 of your lordship's bundle, or PDF 155. There's a passage that starts under the title, Expert Evidence, and that runs through from paragraph 54 all the way through to paragraph 84. And when your lordships have further opportunity to read it in light of what we say, it is, and I don't mean this disrespectfully, but it is what some might describe as a notebook summing up. It records what she has been told and what she has read in relation to the medical evidence, but it doesn't contain any analysis, and certainly no analysis that relates to her finding that there were no contusions, because when this judgment was written, that was not a finding that had appeared, and certainly no analysis about the difficulty that may be presented in the event that she's not satisfied that there is thin film multifocal bleeding. In the same vein, the next passage relates to the concerns raised by the parents. And again, she deals with this in about 4 or 5 paragraphs, but is doing little more than recounting what she has been told by the parents. And it's slightly hard to follow, but at paragraph 99 on page E23, she then reverts back to the medical evidence, because she then refers to the evidence that she's had from geneticists and hematologists and so on. So in that passage, starting at paragraph 54 and ending at about paragraph 106, we submit that there is no analysis. It is simply setting the scene of how she has understood the evidence to be to have been given. Her review, her analysis starts at paragraph 107. And I would please like to take just a little time looking at this. It's at E27 or PDF 171. She starts by correctly identifying that the parents are suggesting that the local authority has failed to prove its case, and they argue there may be a medical explanation which is not presently known or understood. So she understands that that was the case being put on behalf of the parents. She recognises that we have emphasised the unusual features of the case, and she recognises further down that there is nothing about the parents that should give cause for anxiety about their treatment of the child, and that they give consistent histories. And for the bulk of the balance of paragraph 107, she simply recounts the evidence of the parents without comment upon it at all. She does the same, my lord, in paragraph 108, where she simply lists the concerns that the parents have raised. At paragraph 109, she sets out that the local authority say there was a single event, and that is simply a summary of the local authority's case. And then at a paragraph 110, she sets out the points that we make about the unusual features. At paragraph 111, she simply sets out what was observed and concludes then, and this is the gravamen of her judgment, the anomalies highlighted by the parents, this is paragraph 112 at E30, do not overcome the consensus of the medical experts, supported by the treating doctor's description of what they found in surgery. I find that the child had a large cortical bridging vein, a torn cortical bridging vein, which could not have been caused by any identified natural process. We have not satisfied that she had multifocal bleeding and the point about the contusions. She therefore finds, on balance of probabilities, that the child suffered an abusive injury, and that this would have been by way of acceleration or deceleration. And she then says, I next need to consider whether I can decide who is most likely to have caused the injury. And I'll return to that in a moment.
Can I just ask this, Mr. Hyde? Where at paragraph 114, she says that she finds on unbalanced probabilities that the child suffered an abusive injury in the course of an undisclosed traumatic event, has she, prior to that point, considered the arguments for and against it being an accidental injury as opposed to an abusive?
No. And she has not considered the parents' evidence in relation to the specific events that occurred in the period leading up to into the child, collapse.
Sorry, she hasn't considered
She hasn't considered.
parents' accounts of what happened.
Correct.
Right. I'm sorry, Mr. Hyde, I interrupted you.
No, not at all. Because it gives me, my lord, a good opportunity then, if I may, to expand on the point with reference to my grounds. And I'm going to pick up, if I may, my skeleton argument at paragraph 27, which I think is in your lordship's bundle at B40. And it takes us to the point we were just discussing, my lord, the finding on balance of the abusive injury. And I record, which answers your lordship's question, that although she has recorded the observations about the parents' case that they were putting, it's only after that, reaching that conclusion, that the child had suffered an abusive injury, that she then goes on to examine the parents' evidence. And she does it really in two parts. There is a cursory analysis, if you'll forgive me saying that, at paragraphs 118 and 119.
Now, these are the paragraphs which were amended. Oh no, that's
No,
170.
neither of those was
Sorry, my mistake. 118.
118, she refers to the mother saying she was sure she hadn't done anything and was equally sure that the father hadn't done anything. At paragraph 119, she talks of the father saying he hasn't done anything and accepting the possibility that something had happened, but he was unaware of it. And then at 120, she then moves to this curious, if I may say so, sort of Lucas direction, where she reminds herself that witnesses tell lies for many reasons. At this point, there has been no suggestion that either of the parents has lied about anything because she hasn't considered their evidence. But you will see the amendment in paragraph 120. And she says in terms, one of the parents has lied about not knowing what has happened. The evidence is that there was a traumatic event. Both parents deny any knowledge of a traumatic event. They do not have to prove anything. I've made a positive finding on other evidence, which has the effect that I do not accept either parent's evidence on this point, but I've not approached the finding from an assessment of their denial. Now, my lord, I'm not entirely sure what that last clause means, but that is abundantly clear. We say that the reason she has been driven to the conclusion that one of the parents has lied is as a result of her findings in relation to the medical evidence. And my lord, I can, I think, demonstrate that further by looking, if we could please, at the questions that I asked her and her response to that in relation to that paragraph 120. The question, my lord, is at E37, electronic page 181. And I ask her, given she hasn't found that mother has told a specific lie, would she clarify whether the basis for rejecting the mother's evidence that she did not cause harm to the child, accidentally or otherwise, is her finding that the best evidence I have is the very experienced medical consensus that there must, the word she uses, have been a traumatic event. And my lord, we have the amended judgment, but we also have further insight to that at E42, which is the transcript of the proceedings in which we sought clarification. And it's at paragraph H, right at the bottom of the page of E42 PDF 186. And she says to me, yes, and the short answer to your questions 2 and 3 is that one of the parents has lied about not knowing what has happened. So my finding is, the best evidence I have is the very experienced medical consensus that it must have been a traumatic event. The reason for rejecting the evidence of either parent that they did nothing to cause this are because that is the medical evidence and that is the finding I have made. Now, the reason that we say that that is vital is because we say that the jurisprudence is clear, a point that she recognises, that she has to consider the parents' evidence with great care. And equally, we say the jurisprudence is clear that the medical evidence is a part of the jigsaw. And I make it, my lord, if I may, quite clear. If the learned judge had analysed the medical evidence properly, had, as part of her analysis, considered the impact of the failure to make findings in relation to the multifocal bleed and the positive finding that there were not contusions, and then weighed that in the balance against the parents' evidence and reached a conclusion on that basis, I wouldn't be in a position to criticise her judgment. But with great respect to the legal that is not what she has done. She has followed this linear pattern of looking at the medical evidence, forming a solid conclusion about that, indeed using the word must as opposed to likely or on the balance of probabilities, and using that evidence as a justification for her conclusion that the parents were lying. And having reached that conclusion at paragraph 120, she, for the first time, at paragraph 122, which is in the judgment E33, PDF 177, looks at the minutiae of the account given by the parents, albeit only in one paragraph, but for the first time. This is the moment that it features in the judgment. And she talks about timing, and she talks about the mother's case, which is not contested by the father, that the father was alone with the child for 5 minutes. But then she goes on, and this forms one of our grounds, to say this: timing alone does not exclude either parent. The event may have been an accident that took moments only.
Can I say, Mr. Hyde, that when I read that paragraph, I wondered whether the judge was reciting submissions that she'd heard rather than making findings. I wasn't clear when I asked myself that question what the answer was. She starts by that paragraph by saying, arguments for both parents draw my attention to the timing they describe.
I see your lordship's point. I'm bound to say I took it as if it is only a reflection of the submissions, then there is no analysis at all. I took it on the basis that it was an analysis of the evidence.
I mean, it's quite striking that she says halfway through that paragraph, timing alone doesn't exclude either parent. The event may have been an accident that took moments only. Now, I hadn't got any further than just raising a question mark about that. Do you say that is part of her reasoning, as opposed to reciting a submission?
My lord, I confess to have read it that way because, and this may be supportive of the suggestion that it is only a reflection of the submissions that were made. I raise it in another ground to say actually that conclusion is at odds with an adjustment that she makes to the judgment later when she says she rules out accidental trauma.
Yes.
So
well, that's what led me.
I can see.
I was tracking through I forget whether it's your ground or Mr. Tilliard's ground, in which there's probably both, in which this reference to accident is cited.
My lord,
and I was, it does stand out, doesn't it?
it does.
There it is, even though she's excluded accident a few paragraphs earlier.
Yeah.
And I wondered, therefore, whether she was reciting a submission rather than anything else.
Well, I think it's important to recall that she, although it appears in an earlier paragraph, I think it's paragraph 117, it was only an add-on. So that was one of the things that arose. So when the judgment was written, she had not considered that point and ruled out the accidental trauma.
Put bluntly, your point is that when she, again, forgive me, I forget if it's you or Tilliard, maybe both of you, when you drew attention to the question of accident in the request for clarification, you say she changed the paragraph whichever it is, 117, isn't it? That amounts not to a clarification but a change in her reasoning. And you say, but she omitted to change the later bit at 122, consistent with what she said.
Well, Lord, that would certainly be my submission. And for my part, and I'll be corrected if I'm wrong, but it wasn't ever part of the parents' case that there was an accident that we were saying might explain what had happened to the child.
No.
So there wasn't, for want of a better phrase, a memorable event where we were saying this could this have caused it.
But the judge had to consider that option as part of her examination of the local authority case.
Very much so. The reason I say that it wasn't part of our case is because that supports, I think, my recollection that this wouldn't have arisen out of any submissions that we made because they weren't consistent with the case that we were putting to her. And, my lord, while we're on it, there is an important point to be picked up, and it forms another ground of our attack, as it were. What I've described as speculation, having said it may have been an accident that took moments only, notwithstanding that she comes to a different conclusion earlier, but later, as it were. She then observes this. Mr. Smith was able to sleep through a feed, and that
Try to keep the names out of it, Mr. Hyde, if we could.
I'm so sorry.
Father was able to sleep through. Yes.
Father was able to sleep through a feed and could have slept through something that happened just before he woke. And then this, the scream of pain may not have coincided with the impact, but have been a reaction to the pain caused by the pressure of the developing hemorrhage.
Where did that come from?
That was, we say, pure speculation. There was no one had even examined that possibility. Certainly none of the medical experts had suggested that. And standing back, we are looking at, according to the learned judge's decision, a child that has either been shaken or subject to such impact that it has caused bleeding. But the proposition is that the child remains silent until the pressure of the developing hemorrhage, at which point the child screams. So we say if that was in her mind, at the very least, she needed to test that with the experts. And in similar vein, because I'm concentrating on this paragraph because this is really the gravamen of her analysis of the evidence of the mother and father, notwithstanding it's already after the event. There is then this rumination, for want of a better description, of her looking at the mother's interview, and where the mother describes what she did. You'll see in brackets, in question marks, these are entirely rhetorical questions that hadn't been raised by the judge in any course of the proceedings, in which, in the judgment, she perhaps asks herself questions. I'm not entirely sure of the relevance of them, but if they had relevance, again, these are the realms of speculation, or if she felt they were important and she needed to know the answers to them.
So those passages in brackets with question marks are purely the judge.
My lord, yes.
Okay, so that again undermines the theory that this is all about submissions.
I think, my lord, I think I'm confident that this is reasoning as opposed to her playing back, as it were, the submissions that have been made to her. And that then leads her to...
Can I ask you this?
Yes, of
I'm
course.
sorry, not. What about the sentence, 5 minutes may have been a very optimistic estimate? What's that?
It comes from the judge. And it's...
So really, if we look at the paragraph as a whole, the first 2 or 3 lines are submissions and the rest is the judge. Down to
I think
line 4, the medical consensus.
I think certainly from timing alone, the medical consensus could fall into either camp, I think, but from
Okay.
timing alone is, which is the passage that we pick up on our grounds,
Fine.
I submit, is clearly her analysis. And underscored by that final sentence, since at least one of them has not told me what happened, I cannot found a conclusion about what happened on their evidence about timing. In other words, the medical evidence tells me these parents are not telling the truth, therefore I can't rely on what they say.
Where does she consider the parents' evidence individually?
I've taken you to the passage. There's a passage that follows at paragraph 123. It now falls under that heading that she's found that one or other is lying. So she says, I can't distinguish between them unless I accept the evidence that mother was downstairs when the child became unwell, and I can be satisfied that her injury was inflicted at the moment when she screamed and began to collapse. It has the ring of the parents having, as it were, to exclude themselves, and moreover, that was the uncontested evidence.
I hope your clients are here, of course, by the way. I should say, and I hope they understand that if I put points, these are just me testing, it's the court's testing the submissions. So where do we find in the judgment, the judge looking at each parent's accounts separately?
You don't, and that's a ground of our appeal. She considers the parents' evidence together. She doesn't, and for my part, of course, for the mother, who it is agreed by everyone was downstairs when this child collapsed, that was a very important process that
Yes.
she ought to have gone through,
Yes.
but she didn't. And, my lord, if I can carry on paragraph 123, she then says, I found both parents apparently to be trying hard to help me as they gave their evidence. They were both likeable people who spoke about their good fortune in their baby and each other in glowing terms. I accept their efforts to understand the evidence, and mother's diary keeping are consistent with anxious innocence as with trying to find a defence. That sentence possibly needs further illumination. While the child was so desperately unwell in hospital, during a time of COVID and isolation, and during much time when the child was in intensive care and in isolation as a result of that anyway, the mother set about writing a diary addressed really to the child. And we said it resonated with a mother who was deeply anxious about whether her child was going to survive, because it was far from clear whether she was going to make it through. And so we had raised that as something that we invited the judge to consider was relevant and supported our case, which again, no one really disputed, that these were parents who the professionals had observed to be nothing but concerned about their child, even before she became injured.
Yeah.
And I asked the judge for clarification about this, and you'll see then the response that she thought the diary keeping was unusual in the circumstances of being with hospital with a baby who was so ill, and I had to consider whether the mother was trying too hard to make a case for herself as a good parent. And then she further added, the effect of this evidence on my finding is neutral. So,
where I see passages in blue, some of the amendments are in red and some are in blue. And your copy.
So my recollection, as I believe it to be, was that the amendments in red followed immediately our having the clarification hearing. When the judge then looked at the perfected judgment, and we saw we knew what were going to be the passages in red when we left the clarification hearing. My belief is that when she then sent out a further iteration of the judgment, she had further tidied it up, as it were.
Okay.
And the blue then follows as a second amendment.
The effect of that line in blue neutralises this point.
Correct. And then you will see turning to the local authority, pointing out minor uncertainties in the father's evidence, and Mr. Tilliard recognising that the history given by the parents puts the child with the father when she became unwell. But then she says this, without direct evidence of the traumatic event that must have taken place, I cannot find that it is more probable that either parent was responsible, and so both remain potential perpetrators. And again, I asked a question arising out of that, and she says, I was asked if there were other reasons for my finding that mother should remain in the pool of potential perpetrators. And I was pausing there, I was inviting the judge to conduct the analysis that my lord has just questioned me on. In other words, a separate analysis of the mother's evidence. And she says, the finding is based on I was asked if there are other reasons for my finding that mother should remain in the pool of potential perpetrators other than opportunity, and my finding that it was more probable that one or other parent was responsible for the injury, and she says there were no other reasons. So it again underscores the process which the judge has gone through to arrive at the conclusions that she has reached. Well, I've danced around quite a few of the grounds that we make in answering your lordship's question, and I'm conscious I don't want to repeat what I've said. Can I just have a moment just to...
I think you've covered the key points. I think for my part, you've covered the key points.
I believe I have. Can I just look through my documents, see if there's anything else that I need to raise with you? Lord, I don't think I need to expand on it, but in the skeleton under ground 5,
Yes.
I've criticised, with respect, the learned judge for her legal analysis of how she should consider whether each one or other remains in the pool of perpetrators, but it links to the point of considering the mother's evidence discreetly. My Lord, having looked through the document, there's nothing that I want to add. That's my Lord, maybe.
Thank you very much, Mr. Hyde.
Thank you, my Lord.
Mr. Tilliard.
Lord, my lady, before turning to grounds of appeal, can I say that on reflection, I think there's more overlap in terms of the grounds with my learned friend than was first thought and is set out in the document that's contained in the bundle.
Yes, I confess being slightly disappointed with that document. This is not a criticism of you, but I had hoped for something more streamlined when I gave that direction, but never mind, Mr. Tilliard.
Well, I hope that I streamlined it during the course of my submissions, my lord. Certainly, in simple terms, we said our grounds 7 and 11 was the same as ground 1. In fact, 7, 8, 9 and 11 overlap with 1, 2 and 4, but I'll come to it if I can as part of my submissions.
Yeah.
Well, may I start with my grounds 1 and 2, because they can be taken together and they are standalone grounds for the father's appeal, and it concerns what we say is the internal inconsistency on the face of the judgment between paragraph 114, where the learned judge seems to have decided, or does decide, that the injury was a shaking or shaking impact injury. And then when we come to paragraph 116, where the learned judge's initial draft of the judgment said there may have been an accident, the child may have been dropped if she wriggled when picked up by a tired parent. She may have fallen from the next to me, which is the context of the bed, if it wasn't against the bed. On the other hand, the parent may have shaken her or thrown her onto the bed. I cannot speculate. The best evidence is the medical consensus that there must have been a traumatic event. And Lord, I make the point that the accidental examples that are given by the learned judge would be traumatic events. And then in 117, well, if I summarise, it seems to me that what she's saying is it might be more likely to be an accident, but there again, it might not. And that seems to be the proposition that she's putting forward. And so the learned judge at that stage seems to be saying that she is unable to decide as between the two. But, my Lord, when we drew that to the court's attention as a point of clarification, it's our respectful submission that the whole meaning is changed, which of course is the ground 2 of our submission. And what we say proves it to be a change of meaning rather than a clarification is, first of all, on the face of the track changes, it now says something that is obviously different. And secondly, it's the paragraph 122 that my Lord referred my learned friend to during the course of his argument, where she says, how could it all have happened in 5 minutes, as the event may have been an accident which took moments only. Lord,
so your point is the original draft was clear that she wasn't ruling out accident, notwithstanding what was in paragraph 114.
Yeah.
And the amendments to the judgment following the track changes don't sufficiently explain or provide for her change of...
Yeah, it's not a clarification, my Lord. It's changing it. And the fact that it's changing it, quite apart from anything else, if all you're doing is saying, well, I've considered accident, I'm rejecting that as a possibility, you don't give 3 examples of how it might have happened, which is what she does. And my Lord raised whether she was simply reciting the argument that had been placed before her. At no stage did either I or my learned friends submit to the court that this may be an undisclosed accident. So there were no submissions made to the court that might be a possibility, and therefore it must have come from the way in which she was analysing the evidence at that stage of a judgment.
Judges are entitled to change their minds in the course of these processes. And, I mean, you say the change between the original draft, which clearly didn't rule out accident, and the ultimate draft version which did, goes beyond what should be permitted.
My Lord, yes. We say that her analysis, as it appeared in that first draft, was that she wasn't able to distinguish between a possible undisclosed accident and an inflicted injury. And she says in terms, it's not for me to speculate as between the two.
What do you say about the reason she ultimately gave in the amended paragraph 117 as to why she was at that point ruling out accident?
First of all, of course, the learned judge realised that there was an obvious inconsistency between what she had found in paragraph 114 and what she subsequently said, which had to be rectified. And as in other parts of this judgment, the judge clearly comes to the conclusion this is an inflicted head injury. That's how it had to be rationalised.
Well, the reason she gives, as I read it, is that a parent who injured a child accidentally or came upon a child who'd suffered an accident would acknowledge that rather than continue to lie. That seems to be the reason, her reason for excluding accident.
Yes, but of course in paragraph 117, as it originally read, she considers that as a possibility, but there again considers whether a good parent would have caused an inflicted injury. May I go to the judgment? I'm sorry, I'm a little bit trying to find it. Yes, in the original paragraph 117, it might be more likely that an accident occurred, that either parent lost control, did something dangerous, but also more likely that the parent who made a mistake had an accident would admit to it, and that parent whose actions, shameful, even regretted, would try to conceal it by claiming not to know what caused the injury. And so at that stage, it seems that what she's doing is considering two possibilities, one in favour of it being an accident and the other in favour of it being a non-accidental injury, which takes you back to paragraph 116 as originally drafted, which says, I can't speculate as between the two. But then what happens in the changed judgment is she says, well, I've come down on the side of saying that if it was an accident, then they would have disclosed it, and therefore I can exclude it. And so what we say is on the face of the judgment as originally handed down, she did appear to be unable to decide between an accident or an inflicted injury, and that was changed as a result of us seeking clarification of what she was saying. And so at the very least, we say, it shows a seriously flawed decision-making process. May I move on from that then to my ground 3, which relates to paragraph 47 of the judgment and the approach that followed. And it's where the learned judge acknowledges that a combination of symptoms might be relevant to the diagnosis of certain syndromes. My lord, we're not entirely sure what was meant by syndrome in the context of this case, but it then goes on to say that it's wrong to rule out any particular mechanism or injury in or out on the basis of the presence or the absence of symptoms seen in other cases. And as a footnote to the original handed down judgment, she relies upon the Crown against Harris in support of the proposition.
Yes.
The Lord is aware that we sought clarification of that as part of the questions that we put to the learned judge. And she said, well, there wasn't any specific reference in the authority, and she was relying upon, but claimed it was common sense that that was the conclusion that the court should reach. And Lord, in the discussions that took place on the 15th of November, she referred to a number of paragraphs in both Henderson and Harris that she indicated was supporting her propositions, which are set out, in fact, in paragraph 51 of the judgment. And with the greatest of respect to the learned judge, we have looked at those paragraphs, and paragraphs in Harris 207, 208, 211, sorry, 207, 208 and 211 the Court of Appeal said in regard to the absence of typical retinal hemorrhages in 2 of the cases that they were dealing with in the Court of Appeal, they regarded them as neutral, and neutral pieces of evidence, the absence of retinal hemorrhages. In 211, it simply refers to a treating physician's view without any comment from the court at all. And in relation to the reference from Henderson, it is making the point that clinicians learn from each case in which they are engaged. They recognise that which is unknown one day may be acknowledged the next.
So it's sometimes since I looked at Harris, but Harris is the case in which there were 4 linked appeals in the criminal division of the Court of Appeal following the Canning's case and consideration of the so-called triad of symptoms said to be.
That's right.
What was the verb? What's the word? Suggest, not verb.
Supportive.
Supportive of, not conclusive. Supportive of shaking injury, shaking impact injury. They were encephalopathy, retinal hemorrhage, and subdural hematoma.
And thin film subdural
Thin film
hematoma.
subdural. And Henderson is the case about unknown causes, isn't it? It's the case which states in terms the court has to bear in mind the unknown cause.
Well, that's right, and of course that is the very paragraph that was being referred to by the learned judge, and that's the paragraph in Henderson. And so,
What is the authority for the proposition that it's wrong to rule out any particular mechanism on the basis of the presence or symptoms seen in other cases?
well, there isn't authority for that, and my lord, it's the beginning of our argument that that's quite the wrong approach. And actually, if there are features of the medical evidence which are inconsistent with the conclusions that are being reached by the doctors, then those are factors that need to be placed in the balance by the judge when deciding what happened. And that's the argument that we're advancing to this court.
But in other cases, is this legal cases or medical cases, or is it unclear? Where in paragraph 47, symptoms seen in other cases, is this what's it? I don't understand what's it's talking about at this point.
My lord, nor do we. What we're assuming that what she means is that when there are features that are inconsistent with the conclusion that the doctors have been reached, thin film multifocal hematomas that we've referred to, no retinal hemorrhages, we've referred to the cortical vein rather than the small veins that usually give rise to the multifocal bleeds. When those features are not present, we say this is an unusual case when it comes to considering a shaking injury, and the court should take that into account. What we understand the judge to be saying in paragraph 47 is she doesn't need to look at that evidence at all because unusual things happen. And so, as I say, what she seems to be saying is that she's entitled to disregard that part of the medical evidence that militates against this being a shaking injury. And we say she's wrong to do that. It's an important part of the overall evidence that needs to be placed in the balance when considering the medical evidence alone, as well as being part of the overall picture to be considered as part of a holistic approach. And the ground...
Just, can I be clear what you say? She's saying she's entitled to disregard evidence about other cases.
No, that she's entitled to disregard the medical evidence when they say, well, this would be a very unusual feature in a shaken baby case.
Is that what she's saying?
I can't think of anything else she's saying.
I mean, rule out. It's wrong to rule out, is what she says.
Any particular mechanism, so shaking, on the basis of the presence or absence of symptoms seen in other cases. So in other shaking cases that you've been involved in, I've never seen a shaking case without multifocal bleeding.
Which is what the professor said.
Which is what Professor Stavaris has said. I'll come back to that if I may in a moment. But yes, I think that's what she's saying. That's and so it brings me really to ground 6, where we argue the learned judge should have placed in the balance those factors in the medical evidence that should have led her to the conclusion that a shake or a shake impact injury as a cause of the child's presentation was also extremely improbable. And Lord and Milady, you refer, my learned friend, to the finding that the learned judge wasn't satisfied that the child had multi-locational bleeding. And of course, the decision of the learned judge was not just based upon the expert evidence that she heard. And so it's not just the only neuroradiologist she had evidence from was Professor Stavaros, because there was also evidence before the court from Mr. Fellows, who is the surgeon that carried out the surgery and opened up the skull of this child, and said there was only a single bleed from the avulsed cortical vein. There was also evidence from, in the form of reports, from Dr. Fian Williams, who it was accepted during the course of the trial is a well-known expert within these courts, in the family courts, as an expert neuroradiologist. He was the treating neuroradiologist in this case, and his reports do not refer to multilocational bleeding, and it's accepted that he saw the same imaging that was seen by Professor Stavaros. And Mr. Jeroboam said, well, if Mr. Fellows says that he didn't see multifocal bleeds, had there been multifocal bleeds, he would have done during the course of the surgery. So it wasn't, there was more evidence upon which the judge could reach the conclusion that we say, or we maintain that she did. And in our skeleton, we've directed your lordships and my lady to those factors identified by the doctors as being atypical of a shaking injury, and we set them out at paragraph 24
Yes.
of our skeleton.
Yes.
And I don't intend to go through them line by line, but the first point I make, it fits into our ground 4, which is the learned judge's decision in paragraph 79, and she referred to Professor Stavaros' table as showing that a high number of cases referred to had thin film bleeds. And it may be a small point, but in my respectful submission, it's not. The point of qualification that we seek to that, and that of course was a qualification in any event, because it did allow for there being certain cases that he had been involved in where there were no multifocal thin bleeds in the skull. In fact, as you've already been taken to the schedule, well, I'll go to it again if it assists.
Refer to multilocational bleeding.
Yeah. And the answer is, in terms of multilocational bleeding, he hasn't done any cases. So it's not a large number of cases, as set out in paragraph 79. He has never been involved in a case such as this, where there has not been multilocational bleeding. And his evidence was, of the 270 cases of alleged shaking that he'd been involved with as an expert, only 19 were space-occupying bleeds, which is the 19 we see in this table or schedule. And every one of those involved multilocational bleeds. And so it follows that he had never come across a shaking baby where there had been a space-occupying bleed, but no multifocal bleeds.
Right, just a moment.
You said that's what the table we were taken to earlier.
Yeah, yes, it does. Yeah.
So that's precisely what it shows. Never, in his 270 cases,
270 cases of
These
shaking.
were all the cases in which he'd found a space occupying subject.
No, 270 cases are all the shaking cases
Yes.
he'd given evidence.
But these were the of those. Here are the ones with the space occupying subject collections, and in those cases, everyone had a multi-locational bleed.
Yes. And so in his experience, if this is a shake, then the presentation is unique.
Where does the judge deal with this point?
Well, she doesn't. She doesn't, and that's why I started with the paragraph 47, because paragraph 47 suggests that she doesn't have to, because Professor Stavros said it's a shake. And going back to paragraph 24 of our skeleton, again, I won't go through them individually, but I make the point that my learned friend has already referred to, that Mr. Jeroboam confirmed that an avulsed cortical bridging vein is different to the bridging veins that produce thin film multifocal bleeds, typically seen in shaking injuries. Maybe my lord first identified in the case the Crown against Harris that your lordship referred to, which goes back to 2005, where we started discussing the triad. And so it's not just that it was only a single bleed and not multifocal. It was from a different vein altogether. There was no tearing of the bridging veins that you would typically see in a shaking injury. And there was no retinal hemorrhages that you would typically see in a shaking injury, as confirmed by the experts. And all the doctors agreed, either expressly or by inevitable inference, and when I say the inevitable inference, it's from Professor Stavros' table, that if this is a shaking injury, then it is a very rare outcome. But in the end, the doctors say, we can't provide any explanation other than trauma. And so we say, on the balance of probabilities, that is what it must be. And our argument before this court is, whilst that is an acceptable approach for the doctors, it is not, without further consideration, an acceptable approach for the learned judge to take.
Why do you say that?
Well, because it's the point we make at ground 6, where we refer to the decision of Lord Brandon in the Poppy M case, if I could refer to it as that, where he disapproved of what he described as the Sherlock Holmes approach. The Sherlock Holmes approach being that if you can exclude the impossible and all you're left is with the improbable, then that must be the truth. And whilst that's acceptable for Dr. Watson and Sherlock Holmes, Lord Brandon says it is not acceptable for the court to approach the balance of probabilities and where cases have to be proved in that way. And he gives 3 reasons. The first is it's always open to the judge to find that because of the unsatisfactory state of the evidence, the claimant, or the local authority in this case, have failed to discharge the burden of proof. The second is you need to ensure that you have all the possible explanations before all save for a single extremely improbable one can be eliminated. And that's not possible in our submission, where there may be an as yet unrecognised cause to explain what happened to this child. And the third reason is the legal concept of proof of a case on the balance of probabilities must be applied with common sense. The judge must be satisfied on the evidence that an event is more likely to have occurred than not. And if a judge concludes on cogent grounds that an event is extremely improbable, a finding that it is nevertheless more likely to have occurred than not doesn't accord with common sense. And the Lord, whilst at paragraph 51 of the judgment, the learned judge recognised that in some cases the court may be required to consider the possibility that a child has a condition hitherto unknown to medicine, or that the cause of the injury is simply unknown. And she recognised in paragraph 107 that this was an argument raised by the parents in this case. She then fails to consider it as part of her deliberation and reasoning when reaching a decision. And so she knew it was an issue in the case, and we'd argued it, of course, in submissions before her. She refers to it as an issue in the case as part of her judgment, but then never deals with it as part of a reason. And at paragraph 112, the learned judge simply says that the anomalies highlighted by the parents cannot overcome the consensus of medical experts. So in other words, the medical experts say, we can only think of trauma, it must be trauma. And so all the points that the parents have raised, that doesn't deal with that. And in our respectful submission, that doesn't adequately deal with the points that were being raised before the court.
You had a number of alternatives to put to the experts, which you did, didn't you? You had infection, because she had a C-reactive protein elevated. There's a history of aneurysm in the family.
Is it? We did. We went through, and that's, I'll come back to it later in my submissions, but Lord, that's why this case is taking so long. We did go through all possibilities, and I can't put before you a medical explanation for the avulsed cortical vein. And that's where we're left, and that's why my learned friend has referred you to the authorities that say sometimes there are just medical causes that are unknown and the doctors are unable to identify. And of course, there's been some beyond the bounds of possibility. First of all, there are authorities that your lordship will know of that say, well, sometimes you just have to say, well, there's perhaps an unknown medical cause. And there are unknown medical causes. And when you cross-examine doctors, they accept that what's not known today can be known tomorrow. And your lordship will have seen the change in the views, particularly in relation to shaken babies and the symptoms or the signs that are shown as a result of shaken babies. That has changed dramatically over the last 10 years. Until MRI imaging was improved, we all thought there were very frequently both chronic and acute bleeds. And so it was said that there was an older injury. And then it was decided that that wasn't the case, that there was cerebral spinal fluid that was leaking into the subdural space and making it look darker than it would otherwise have looked. And so the whole view as to whether there were two injuries or one injury changed. I simply give that as an example because for the court to say that if the doctors say it happened, then in our respectful submission, that doesn't really reflect medical science and the approach of medicine to changing diagnosis. And one of the considerations that we say that the court should have taken into account, sorry, I changed the plug. One plug isn't charging my laptop.
Before you go on, can I just ask a question?
Yeah.
I just really want to understand a little better what you would say the impact of the judge's findings on contusions and multilocational bleeds was on the way the medical evidence or the expert evidence came together. Because as I understand it, Professor Stavaros, his evidence was that there were both of those things, contusions and multilocational bleeds. The other experts didn't either defer to him or didn't directly conflict that. The other experts, as opposed to the
treating
treating physician.
Mr. Jeroboam said it would be dangerous to find there was multifocal bleeding. I think I'm right in saying that. I look around in case anybody is correcting me, but I think that was his evidence.
I see. But other experts may have deferred to Professor. I mean, what I'm trying to understand, I suppose, is when you get to, for example, the joint meeting, which is short, is it fair to say that would have proceeded on the basis that those elements were present? Or is it not fair to say that?
Well, lady, with respect, I don't think it is fair because, of course, that's why we have live evidence and we cross-examine the experts. And very frequently, when the experts are cross-examined, they changed the nuance on their evidence, if I can
Yeah,
put it in
but
that way.
What's behind my question is this: everyone seems to agree that there was a trauma, and I'm trying to understand that in the context of the judge's conclusions on those other features.
Lady, all the doctors agree there was a trauma because they say we cannot think of any other reason why this vein would have been avulsed. So that's what the doctors say. And because they can't think of any explanation. But in terms of whether or not the presentation is typical of a shake or a trauma, they all say this would be very unusual or atypical. In other words, we've never seen it before. And so there are many factors that suggest this is not a shaking injury within the medical evidence. And added to that, one has to look at the practicalities of it. And I haven't come to it yet, but I shall deal with it now. These are very good parents. I don't think anybody is challenging that. And the laws has heard a great deal of evidence about it. The local authority accepted it both before and after. And of course, they've had 2 years plus now to observe these parents with their daughter. And there is no criticism of them at all. And they have given an explanation as to what happened. That explanation involves a 5-minute window when this could have happened. And I've referred to, or in our skeleton argument, you will have seen the argument we placed before the court. Does it start? I think it starts at paragraph 10, about what's said. What would have had to happen is very often said in terms of shaking injuries, that it's an otherwise good parent, that a momentary loss of control shakes their loved child. And nobody could possibly suggest we would submit that this was done by a malicious person. So if it was ever going to be a shake, that's what it was going to be. He was asleep when the mother goes downstairs, as was the baby. In that 5 minutes, he'd have to wake up, pick up the baby. The baby would have had to have done something for him to lose control. He would have had to been so annoyed with the baby that he'd shaken the baby, then had the wherewithal to get back into bed, because when she comes through the door, having heard the scream, he is not standing up in a position where he might have shaken the baby. The baby is not on the bed where he might have thrown the baby. He is in bed with this child in his arms, looking very concerned. Now, the point we make, in the real world, you don't get an aggressive shake by an otherwise reasonable parent in that sort of time period. And you don't get a parent ignoring the fact that their little newborn baby, that everybody agrees who's seen them, loves them dearly. Instead of doing something about the child that's clearly ill, does something to cover it up. And the idea that they're both in the pool of perpetrators and they somehow might have conspired together to prevent the doctors that were treating their very ill child in an appropriate way, in our respectful submission, is a factor that should have been placed in the consideration by the judge as part of the overall evidence, the wider canvas. And had she done so, the conclusion is, well, it's vanishingly unlikely that either parent has inflicted an injury. So you have, on the one hand, it's vanishing unlikely that either parent has inflicted the injury. The other hand, the doctor's saying, well, although the presentation is not typical of a shake, we can't think of any other explanation for an avulsed vein. And the court has to decide whether, on the balance of probabilities, the local authority has proved its case. And we say, had it been done in that way, had the court approached it in the holistic way, this is the medical evidence, this is the part of the evidence that doesn't support them, part of the medical evidence that doesn't support this being a shake, but this is what they say happened, and the court seems to be accepting that they're generally honest, caring parents. This is what they say happened. How likely is it that a shake took place? And then say, look at these parents generally. How likely is it that either of them would have shaken the baby? And had they done so, that they wouldn't have taken immediate action to receive the appropriate medical care? This child was very ill. They were in hospital. Had either of them done this, and had either of them done this, they would have said something. That's what we say. And that's part of the holistic approach. That's part of the wider canvas. And really, I've gone completely off piece in terms of my submissions, but may I continue with
So just drawing that point together, you're saying that the judge should have taken those points into account. The
Yeah.
strong often called wider canvas points, into account before reaching a conclusion at 114 that this was an abusive act.
Yes, and we say in the context of this particular case, the wider canvas is a very strong argument.
It is in all cases.
Sorry?
It is in all cases.
To take into account...
We're both making rhetorical points.
Yes,
Mr.
no, but to take into account in all cases,
Yeah.
it's a very important point. But in the context of this case, it really goes very strongly in favour of this not having been an inflicted injury. And perhaps the irony of this case, and my own friend makes the point in her submission, is that, well, how could we say that the court didn't take into account the wider canvas? Because this case has taken 87 weeks. And it's taken 87 weeks because the court, right at the outset, recognised that these were very good parents and it was very unlikely that they would have caused an inflicted head injury. And therefore, she followed every single inquiry, medical inquiry that could be made to see whether or not there was a medical reason. But having done that, and that's very much to her credit, and it was to hope that that would be the outcome, the reason she did it was because she recognised the wider canvas points that I've been arguing before this court. But then when we come to the judgment and the decision-making process and the analysis, unfortunately, it's completely absent. And it really should have continued into that final analysis. And it should have been taken into account. We say, had it been taken into account, the balance comes down in favour of the local authority not having proved that this was an abusive head injury.
Okay. So you've covered quite a lot of your case. What part of your grounds have you still to deal with?
May I just look? I suspect not, but can I just turn round to my open? No, sorry, come on. So, it's paragraph 10, sorry. Paragraph 10. Oh yes, Lord, the reference to the ground 10 is a sort of standalone point, I suppose. And it's the evidence of the parents that they had noticed from birth, really, that there had been something wrong with the child's left eye.
Right.
And that had stopped being the case immediately following the surgery. And perhaps, in our respectful submission, that's a more important point than saying that they noticed that there'd been something wrong with the child's eye. And that the learned judge dismissed this as even having happened because the doctors viewed photographs, as did she, and their view was that there was nothing to see. And it's at paragraph 95 and 108 of the judgment. But my lord, the point we make is these are intelligent parents who've been found to be generally honest witnesses in this case, who appeared to be trying to help the court, and that's taken from paragraph 123 of the judgment. It was their child, and they are both adamant, firstly, that there was something wrong with their child's eye up until the surgery, and also that it was rectified immediately after the surgery. And in our respectful submission, there really was little basis upon which the court could or should have just dismissed this as something didn't happen, because both she and the doctors couldn't see anything in the photographs. And what we say is it adds to those unexplained presentations in this case that do require careful consideration. It's a piece of evidence in the case that should have been put in the balance. And it leads perhaps to thinking that there was something else going on here. Well, I think finally, what I would like to say is this. I know that we've said in the skeleton that what we seek is the matter to be referred for a retrial before another judge. And that's the points made on behalf of the mother in their skeleton argument. But your lordships, my lady, may take the view that you could go further than that in the course of this appeal. And you could conclude that had the learned judge taken the holistic approach that was required of her, and had she considered the improbability of this being a shaken injury on the medical evidence, and then placed in the balance the wider canvas and what's known about these parents and the improbability of them deliberately having inflicted an injury, and that having happened in the 5-minute window that I've addressed your lordship on, you may take the view that you could say without any further delay that the learned judge would or should have concluded that the local authority had failed to prove its case and to bring this matter to an end today. My Lord, we are in the unusual position that the local authority and the parents agree the findings and the factual background upon which a decision should have been made. And the subject of the appeal is really the analysis of the information that the learned judge had and the conclusion she reached. Because, and my Lord touched on it right at the beginning of this appeal today, this little girl has not had a normal life with her parents from the age of 9 weeks, and she's now 2 years, 4 months old. The local authority and the guardian agree that these are essentially good parents. There are real concerns expressed by the guardian and others that the child is forming primary attachments to her grandparents, and it's at paragraph 9 of the judgment, which cannot easily be undone. And now, through no fault of hers or the parents, there may be a further delay, which will inevitably cause further harm to the child. And so we would invite Lord and Milady to at least consider that when deciding how this matter should proceed. Because if it goes for a retrial, inevitably there's going to be further delay. Lord, I know that the Lord has done his very best to get this matter before the court sooner rather than later, and we are all very grateful to the court to get it before the court so quickly. But it still took 4 months.
Yes.
Unless I can assist you further, I think that's
Anything further? Anything further? No, thank you very much, Mr. Tilliard. Thank you. Ms. Harris.
My Lord, can we just...
There's only one place you can.
Sorry, there's no place.
That one didn't work.
Thank you,
Yeah.
my Lord. My Lord, what I plan to do is make some general points that hopefully respond collectively to the points that have
Yes.
been made. And if at the end of that there's any specific grounds I haven't dealt with, perhaps I can deal with those then. Firstly, my Lord, I just want to remind the court of some pieces of the written medical evidence. The first is Professor Stiveros at F49.
Yes.
Which is PDF 251. And it's the first paragraph on that page when he makes the point that I've seen such avulsions occur as a result of both shaking injuries as well as impact injury. But I note to the court that in accidental causes of such avulsions, there's a clearly recognised injury, and that's when he goes on to give his various examples. He then says, I have never seen such an avulsion occurring accidentally de novo without an appropriate traumatic event being recounted, and certainly not in an immobile child of this age.
Yeah.
So, my Lord, that did not change during the course of the hearing in terms of his evidence, despite the exploration of the conflict between the experts in respect of the injuries. If
You've taken us to one paragraph in his report.
Sorry, which page are we on again?
F49.
Ah, misheard.
He also, of course, identifies earlier in his report what he sees as other areas of bleeding, and he refers to the contusions. And his conclusion is in the paragraph beginning in summary. Therefore, the constellation of imaging features would indicate a traumatic cause.
My lord, absolutely, and that was his position, that he was the expert that very much gave the evidence of the 3 injuries. But I simply remind you of, because you've been taken to what he has or hasn't witnessed in typical shaking injuries. This, of course, is an example of him giving us his evidence about what he has or hasn't seen with avulsion injuries.
Okay, so when we consider the table which he produced, this is your response to that.
My lord.
On the other side,
yes.
this is what he said about
My
them.
lord. And then I just, to perhaps complete it as it went through the experts meeting, if I could take you to F127, which is 329.
I'm so sorry. Page number again?
F127.
Thank you.
And this is discussion when you know that there is a difference of an opinion between Professor Stiveros and Mr. J. Mohan. And at 16 minutes 40, what is being said by Mr. J. Mohan is what this is likely to be as a traumatic event involving adult care of this child. Whether it's just a shake or a shake and an impact, I would suggest is probably difficult for us to be specific and probably not that necessary. And then it goes on over the page where all of the experts go on to agree at the foot of F128 into F129 that to the extent they have considered the other injuries, it doesn't affect their opinion of the conclusions that they have reached.
Where do the doctors consider what the judge ultimately found? That's to say, no multifocal bleeding, no contusions, the rupture of one major vein alone, no retinals, no other signs. Where do the doctors in any of this evidence consider that constellation which the judge found?
Well, Mr. J. Mohan considered the avulsed vein in his first report without the multifocal bleed or the contusions, because at that point
That was his view.
Yeah, he hadn't seen Professor Stivros's report and he hadn't seen the MRI scan. It wasn't until the experts meeting that he then came in line with Professor Stivros. He goes on in that report to discuss shaking impact or impact alone, and with all of the experts, whether they were considering impact alone or impact with shaking, they all made the point that it would have to be a soft yielding object or surface because of the absence of external injuries.
Can we just look at what Mr. Jeremy said?
Certainly, it's F8.
8.
F8, I think, is where the report starts.
So he is here expressing a view on what the judge ultimately, in line with what the judge ultimately found. Is that right? That's what I was trying, probably not very helpfully, to ask you.
Absolutely. His starting point was that he was looking at an avulsed vein. And there was some debate with him in evidence as to the extent or not of the contusions, but don't need to go into that. My lord, so his report is relatively short. It starts at F8 and runs into F18.
Yes.
And so at F14, at the foot of that page, he sets out the injuries that he says he observed, which is the left-sided acute subdural hemorrhage. And then at F15, alongside paragraph number 180, is when he considers it in the context of a mechanism.
So he refers there to impact being the most likely. Where
Yeah.
does he refer earlier to?
Sorry, milady, are you looking at
He says-
paragraph 180?
Yes, I am. Has he previously referred to impact?
I don't think he does within his report, because he's setting out up until that point and the discussion starts, he's setting out the background and the imaging.
Okay, so he's, if I understood this correctly, he's actually saying impact rather than shaking.
He was at that point, certainly, because he only saw the avulsed vein.
Or did he vary that opinion?
He, during the course of the evidence, he accepted the evidence of Professor Stavros as to what he saw on the MRI scans.
Yes, but of course that's not what the judge ultimately.
No, and my lord, that perhaps a secondary point in relation to that is the point that's already been explored as to how far the judge actually went in respect of the multifocal bleeds. Her saying that she was not satisfied they existed, as opposed to with the contusions where they went, she went a little further. But of course, we don't have the experts dealing with, excuse me, sorry, the avulsed vein and the multifocal, but no contusion. We have Mr. J. and Mohan dealing with the avulsed vein in that first report, and by the time we have Professor Stavros' report, we have the other two injuries being brought into play. So, my lord, that was evidence that was before the court, and of course, the learned judge takes into account, listens to, considers the medical experts, but it's a well-founded principle that the experts don't decide the case. Ultimately, the judge decides the case. And within considering all of the other possibilities, she considered all of those raised by the parents themselves, the infection, the sepsis. She considered, although it was nobody's case, the potential of an accident, as she was entitled to do, even if the case wasn't put in that way. But despite that, she wasn't satisfied of the multifocal bleeds. She didn't find that there were contusions, but she felt able to find that the avulsed vein was responsible for what was then seen in Mia. And in respect of the findings themselves, we have the finding document, my lord, and it is quite specific in some ways, but more general in others, in that what she finds, and it's at D1.
Was this drafted by counsel on the basis of the judgment?
It was, yes, and it was agreed by the judge. And it's paragraph 3. This would have been by way of an acceleration or deceleration action with or without impact against a soft object, and it caused a significant injury to her head.
Can we just come back to this point that we've been focusing on in the last couple of minutes about impact versus shaking? So Mr. J. Mohan's, let's get right to surgeon, isn't he? Mr. J. Mohan's evidence at the outset was that that was more consistent, that if it was just the bridging vein that was ruptured, just the major vein that was ruptured, that was more consistent with impact. That's my phrase, actually, it's not his. Where, for example, did the judge address the question, well, if this was a shaky injury, why wasn't there other evidence of bleeding?
My lord, we've seen the judgment, it's not in there, and I don't think I can...
I mean, the point is that with a shaking mechanism, you have a variety of forces. The brain moves, I know this is painful for the parents, I apologise. The brain moves around inside the skull, so you get lots of different forces, and the fragile veins break at different points, hence the multifocal bleeding. Contrast an impact which hits at one point, where it may be matter for debate, but that causes the single larger vein to fracture. Where did the judge consider? Did the experts consider in the evidence, and did the judge consider, if this was shaking, why weren't the other veins fractured?
The extent to which the experts considered it, I know there was extensive cross-examination of the experts.
Yeah.
Of course, we don't have the transcripts.
I
and I
know.
don't want to try and recall something that may not be accurate. But what the judge did have was one injury about which all of the experts were agreed existed and could have been an impact against a soft yielding object. And ultimately, that was what her finding was.
Well, just to be clear, her finding, as I understand it, is shaking with or without impact.
Sorry, that was her finding in relation to what injury existed.
Yes.
Well, no, that's
Right.
her finding as to the cause.
The cause, yes. But
Sorry, I don't dispute that at all. The point I was making was her finding was in relation to there only being one injury. I take entirely
I
the
see.
point that it then goes further as it considers both possibilities.
But she doesn't find that one possible impact, that it was impact without shaking, or even that it might have been impact without shaking.
That's her finding
Yeah.
as she found it related.
I mean, can we go back to Dr. I'm sorry,
No,
to Mr.
certainly.
JMO? It is a shame we don't have the transcripts, but we are where we are. We did try to get them.
Yes.
We won't go over that history again. I've seen F15. I have seen large draining vein torn associated with clear findings of a shaking injury, i.e. injuries to other parts of the brain and accompanying changes within the posterior fossa, and also described in the eyes. But none of these are sufficient to override the most likely finding in this case, which is an impact. So, isn't the effect of that evidence that the finding which the judge ultimately made, that there was just one rupture, that was likely to be caused by impact rather than shaking, because with shaking, he's seen ruptures to this vein in shaking cases with clear findings, other findings to other parts of the brain.
My lord, yes, that's what he says, and I simply also put that alongside what Professor Stiveros said, which is that he had never seen a avulsion occurring accidentally or de novo. So that was the evidence that the judge had to grapple with, that the experts were telling her that there would be a traumatic event for the one injury. We then, of course, explored in greater length the three injuries.
But forgive me then, how is the conclusion of the judge's conclusion about the expert evidence consistent with the finding as recorded in the second sentence of 3, which is that the injury would have been caused by way of an acceleration or deceleration action with or without impact?
Well, that was the evidence of Professor Stiveros, and I accept that was on the basis of the other injuries also being present. My lord, it perhaps goes back to the position that the judge reached in relation to the multifocal bleeds, which that she said that she wasn't satisfied that there were multifocal bleeds. does that make it a positive finding that they weren't there, or did she
Well,
just?
what's your submission on that?
My lord, I don't want to rewrite the judge's judgment for her. She simply says she was not satisfied that the multifocal bleeds. She could find the multifocal bleeds, and I don't know that I can go any further than that. That's saying those are her words. In terms of my submission, my lord, I don't think it's as straightforward as to rule that out as her saying they simply weren't there, because you have the experts that were telling her that they were there, as in Professor Stivrose. My lord, in terms of the unlikeliness of an event and whether this is medically unexplained, the judge does, of course, compare this at paragraph 51, in her judgment, to unlikely scenarios. And at paragraph 52, she talks about nothing being 100% in medicine. So she was reminding herself of those principles. As to how she dealt with the evidence, my lord, the point made collectively on behalf of the parents is that she made findings in respect of the medical evidence before coming to consider the parents' evidence. My lord, I dealt with it in my skeleton argument, and I think you explored with Mr. Hyde the various paragraphs that were relevant. But if I can just bear with me a moment, I'll just refind it.
So 114, isn't it, and thereabouts that we were focusing. E30.
My lord, I was dealing with it in my skeleton argument, which is at B67, and it's the learned judge reaches the conclusion she does in relation to the medical evidence within the judgment. But what I seek to do is set out for you the parts of her judgment when she quite clearly is taking into account the parents' evidence. And it is said, of course, against the background that there was a very early concession in that judgment, or acknowledgement in that judgment at paragraph 6, that the wider canvas issues that are often seen do not exist in this particular case. There is no criticism made of the parents by the local authority. That continues to be the case. And that was the starting point of the judge considering the parents' evidence. And what she goes on to do throughout her judgment is she considers their explanations generally at paragraphs 29 and 30. She considers the alternative explanations at 85 to 98. She reminds herself at paragraph 50 as how she must approach the parents' evidence, forming a view as to their credibility and reliability. And you've already been taken to paragraph 120 and 10 when she deals with consideration of whether anybody has told a specific lie or not. So, my lord, clearly recognise the point that's made on behalf of the parents. The judge had the benefit of hearing the evidence. She had the benefit of knowing the parents' arguments before, in effect, they gave the evidence, because they had been put to the experts. She, in my submission, clearly had that evidence very much in mind as she progressed through her judgment when looking at what findings she could or couldn't make. And if she of course reminded herself of the test she must apply. In terms of the parents' evidence itself, they gave evidence. You don't have a transcript of that. The focus their evidence in terms of exploration was very much on those moments of the 19th of February and what did or didn't happen during that short period, which may explain the focus on timing, because that was what the focus of the evidence was. And the point was made on behalf of father as to what would have had to have happened for this to have been an inflicted injury, and the short space of time and father's actions. What the judge doesn't do is speculate about those precise moments, and ultimately the finding she makes is a pool finding. And my Lord, submissions have been made about the consideration of the accident point. The judgment deals with that. My Lord, in my submission, my reading of it was what she was seeking to do was not to speculate, but she was raising an issue that she considered. And again, in my submission, I don't accept that it goes as far as to actually change the meaning in revisiting the judgment and the clarification points. And my Lord, in relation to the point made on behalf of father dealing with what was observed around Mia's left eye by the parent, child.
We got your points on that.
Paragraph 34.
Yeah.
It's Dr. Rylance has considered that at some length, my Lord. My Lord, I hope that covers the general responses. I tried to focus on the 2 points in relation to the 3 injuries and the evidence of the parents. The perhaps more general points about an appeal I'm sure you have as to there should be compelling reason for an appeal court to interfere. This judge was in the privileged position, special position of hearing all of the evidence. My Lord, perhaps I should just clarify with you whether there are any of the specific grounds that I haven't dealt with that you would wish me to.
Can I just go back to this question about the accident? So we know that in the original judgment, the judge has a look at whether it might have been an accident. Is it your submission that she ruled that out in the original judgment?
She considers it and she doesn't make a finding that it could have been an accident.
I mean, that's clear when you come to the clarification. She decides against accident, but it's not very clear from the original form of 117. You say that
116 and 117.
it's 116 and 117. Is it your submission that reading 116 and 117 in their original form, she did decide that it was not an accident and that it was an inflicted injury?
Well, she's gone on to make a finding at the end of the judgment that it was an inflicted injury.
That's
So read in the context of the findings that she ultimately makes.
that's 114 when she says it's an abusive injury, which comes before this passage about accident. So that seems an odd way to do it. To do the. I mean, I understand 113. She gets to the finding there's large torn cortical bridging vein, which could not have been caused by any identified natural process. 114. She then goes on to abusive injury, the finding of abusive injury, and then she goes to accident. What was she doing in the unclarified judgment in looking at accident? Was she looking at that for the sake of completeness and then rejecting it?
Well, certainly, I don't see that she makes any reference to accident earlier in that judgment, so I accept that point. I don't know that I can say any more than at the point she clarifies it, she makes it clearer that she does not accept it. But the existing judgment was that there was an inflicted injury. That was the judgment we had, so she had made that finding.
So your case really is you invite the court to reject the submission that this was a change in the judgment. She wasn't genuinely clarifying it
My lord, yes.
because of the ambiguity that counsel identified.
It still leaves the reference to accident in 122, where she's dealing with the timing point. I'll explain, because as I read 122, what she's doing is addressing the argument that Mr. Tilliard addressed to us, that there simply wasn't enough time in the 5 minutes that the mother was downstairs for the father to wake up, get frustrated, do something, and then get back into bed. That's the argument that she's addressing in 122, and her answer to it is, it might have been an accident that only took moments. Now that doesn't sit comfortably with her having ruled out accident at 117.
My lord, I see the point, but the overall finding at the end of the judgment is that it was an inflicted trauma.
But then what is the answer to the timing point? I mean, the answer might have been, but this is not what she says. Well, actually, I think that it was a great deal more than 5 minutes and there was plenty of time to do it. But that's not the answer she gives.
No.
I mean, she does say 5 minutes may have been an optimistic estimate.
Yes.
She does. Thank you, my lord.
Yes. Okay, thank you.
Is there anything?
Well, what do you say to Mr. Tilliard's submission that it's open for us to effectively reverse the judge's finding and reach a conclusion that the local authority has not proved its case?
My lord, certainly within your powers is my understanding of what you can do. Whether it is what you choose to do in circumstances where a first instance judge has heard the evidence and you should be cautious to substitute your own views for hers, but it is a course of action that is open to the court.
So,
and
of course, we'll be cautious, but you're not submitting that this is a case which we should definitely send back.
my lord, no. I think that is a matter for your consideration. This it is a case, we have in mind how long this case has been going on.
Yes.
And it has been going on a very long time.
Why would it? Yeah, okay. And do you want to say anything more about how the family are doing now? I'm conscious the parents weren't in court when they heard the very positive things being said earlier.
There never has been, and there is no criticism of these parents. They have had to work with the local authority in what must be incredibly difficult and distressing circumstances for them, and they have done that without question. There has been no difficult relationships with the professionals. They have, in a perfectly appropriate way, when it's been necessary, challenge things, listen to explanations, and discussions been able to take place, but nothing inappropriate. Their care of their child has been second to none. There is no criticism of the care that they provide. The local authority have acknowledged from the outset that but for this event, we would not be here. And they, of course, have had to not just work through it with us through the life of a normal care case, for want of a better phrase, but one that has gone on for this amount of time. And that hasn't impacted upon their ability to work with us. What it has given the local authority the opportunity to do is see them caring for their child over an incredibly long period of time. And I think I am safe to say is not one element of criticism of their parenting has been raised.
Thank you. Thank you very much, Ms. Harris. Do you want to say anything by way of reply? First of all, Mr. Hyde.
No, I think the only thing I ought to do, and I'm not sure whether it illuminates further, but in response to my Lord's questions about the accident and speculation, there is a passage in the transcript when we attended before Her Honour Judge Cronin.
Okay.
It's in your Lordship's bundle at E43. And it refers specifically to Mr. Tilliard's question at paragraph G and H at the bottom of the page.
Okay, well, we'll have a look at that.
You may want to have a look at that.
Thank you.
But other than that, my lord, no thank you.
Thank you. Mr. Tilliard, do you want to say
My
anything?
Lord, there's one correction I need to make, and that's all. I referred to Dr. Williams having been the treating neuroradiologist. That's a mistake on my part. It was Dr. Leichman.
It was Dr. Leichman.
It was Dr.
And
Leichman.
so confident as you say it was Dr. Williams that I thought better of correcting you.
Well, my Lord, I do.
Dr. Williams may be an expert in another, in your part of
I
it,
think-
Mr.
I think-
Tilliard.
I think that was my mistake, my Lord. But anyway, it's Dr. Leichman, but the same point applies. He is a regular expert
is.
in the family courts,
He is.
and his evidence is taken into account.
Okay, I shall make a note, Leichman, not Williams. Well, thank you very much, all of you. Well, we're going to reserve our judgments. I hope very much, I can't promise this, but I hope very much we'll be able to deliver judgment before Easter. That will be my aim. What will happen is we'll send out a draft judgment to council. That's an opportunity for you to correct any typographical errors and minor factual errors, not obviously for re-arguing the case. And then after we've received those comments, we'll hand down a judgment that will be done remotely under the new rules. No need for you to attend. We'd be very grateful if, when you receive our draft judgment, you would endeavour to agree a form of words for the court order reflecting our decision. If there are any issues between you, please can we have short written submissions on those issues, which we'll resolve on the basis of paper only. Bear in mind that the draft judgment is intended, is confidential document and must not be disclosed beyond those permitted to see it, in accordance with the rubric at the top of the order, top of the judgment. Thank you all very much.